Hi, I'm Rich Marsden, a partner at Maynard Cooper Gale. I practice in the area of corporate law, M&A transactions, private equity. Spent a lot of time helping clients raise capital, and there's some interesting topics we can talk about today. And I will say that the law has changed. There are a lot of interesting regs that came in at the end of 2020 that have not gone effective yet. I'm going to point to some of those changes as we go through this. So as I mentioned, this presentation is about raising private capital. So a few big questions that companies have, particularly when they haven't raised money before. Is the company ready for outside capital? How much should they raise? And what should be the form of the raise? What type of security? Should it be debt? Should it be equity? Combination? And then, sort of finally, who are these investors? How do I get to the investors? How do I do that in a proper way? What laws do I have to follow in reaching these investors and placing my securities? And we're going to see if we can address these questions through this presentation, or we will address these questions through the presentation. So a couple things before you even start the raise. You're at a place, you're a company, you're at a place where you know to further the company, to be able to increase sales or perhaps develop product, you're going to have to raise capital. More than likely you've had whether it's friends or family, or perhaps not even that, just the founder's capital. You've been living on that, perhaps not even taking salary, but you're at a point now where you're ready to take other people's money. That is a big jumping off point. In a company life cycle, it's very much like when you take on the first employee. Things are getting very real. And there's a lot of duties that come into play when you take somebody else's money. So the first thing you want to do is make sure that the company's ready. Preparation. So you're going to look through your corporate records, make sure you have corporate records, understand who your shareholders are. It's surprising how many companies don't have a clear view to their shareholder list. So we want to understand that. We want to make sure that the company's completed all its filings. It's up to date in any kind of tax filings. It's in good standing. Its business license is current. These are all things well in the control of the company, and should be all up to date. It reflects well on the company, particularly if you're going to have any kind of due diligence process. And you want to show well there. You're going to have make sure your resolutions are up to date. Company meetings approving, raising capital if you've made that decision. So these are all in preparation. And then, further to that, you want to make sure that your managers, your board members, everybody understands what their role is with the company, particularly when you're bringing in this outside capital. You need to understand your fiduciary duties. No longer as a single owner are you just taking care of your own family situation. If you're a single owner, you've got shareholders. As a board member, your duties of the board run to maximizing value for your shareholders. Now, they're not your shareholders yet, but when you bring shareholders on board, your duties will run to them. So it's worth having those kind of discussions with your advisors so you're clear about that. Then you get to valuation, and that's a tricky topic. For an early stage company, often you hear garbage in equals garbage out as far as calculations and calculating value. And you're basing your value perhaps on predictions of what's about to come. And you don't have a lot of past history. Maybe you do, maybe you don't. But certainly you have to have that question answered in most cases. There are some techniques. And for instance, and we'll talk about debt shortly, but if you're borrowing money, whether it's a straight borrowing or borrowing on a convertible note into equity into the future, you could punt the question of valuation. But if you come to the point where you're going to raise equity capital, that question has to be answered. Also, you can use that valuation discussion to help if you value options, if you're going to do some kind of equity plan for your employees. So a discussion with the accountants, valuation experts, your lawyers are going to have some thoughts on process, if not actual value. They can tell you what they see, but that would not typically in the business of putting a value on a company. But certainly, most of your advisors will be able to give you some range of at least formula approaches, values that come out of formula approach. The management itself, management and fundraising, hand in hand. Management needs to understand what its role is, how they're going to move through the process, and more importantly, obey all state and federal laws. And we're going to get to it in a little bit, but certainly there are federal laws to take into consideration when raising capital, and there are state laws. And in some cases, federal law preempts state law, and as we'll see, we'll be focusing on a particular type of raise, be a Reg D raise, where in most cases federal law preempts state law, and we'll talk about what that means. As part of getting ready to go out and effectively convince somebody they should be investing in your company, it's very helpful to have the roadmap, the business roadmap, the business plan, if you will. Probably what you want to stay away from, or what you want to stay away from, are just some kind of generic business plan. You can get a Microsoft business plan. There was a period there where every other business plan that I saw looked like the next or the previous, because they were getting generated from some kind of software package, pump in some numbers, and it generates a so-called business plan. Then you have companies who believe a business plan is nothing more than a spreadsheet, maybe with some financials and projections. It's really a combination of things. That we certainly have financial projections, but a discussion of the management, strengths, weaknesses, competition, marketplace, why you are uniquely situated to solve a problem. All these things are part of developing this roadmap. And, in the perfect world, you'll have sort of a 12-month, 24 and 36-month plan. And it's really an action plan, things that you will be doing and hopefully accomplishing along the way. That will include asset allocation, use of cash, use of proceeds, what the sales opportunities are, and potentially what your sales efforts will yield. So the term of art used, at least by venture capitalists, is signals of traction. Sophisticated investors want to see signals of traction built into your plan, your action plan, your business plan. Those signals of traction often translate into successes, whether at product placement, sales, growth, penetration. These are sort of metrics that can be measured. And to the extent that we can have some of that in place before a raise, your first raise, it makes that raise that much easier. It will reduce the at least perceived risk of the transaction. I've got a couple slides here about bad actors, and we're not going to go into all this detail, but just know that when you raise capital, even in the private markets, and you want to use an exemption from registration, because that's, but whether you're raising debt or equity, what we don't want is for that raise to be considered some kind of public offering. And to avoid that, we need an exception from registration, which is the general rule. And whether debt or equity. And we're going to talk about that and safe harbors and how we go about that. But we should always keep in mind that if you have, as a, what's called a covered person, was really an executive or a large owner or director, somebody important in the organization, if they are considered a bad actor under the rules of the SEC, you may be prevented as a company from benefiting from those exemptions. And so you can look through the detail, but really, it comes down to exactly as it says, a bad actor, somebody's being convicted, subject to an order or judgment that prohibits them from engaging in securities transactions, convicted of something related to improper sale of a security, for example. And I think I got a couple of pages of that. So just beware. There's bad actor forms. When companies go public, all their officers fill those out. But it's good to know where your officers stand that way, because you don't want to get knocked out from these exemptions. So you're getting close to a decision time, ready to raise capital. Now it's, what kind of capital is it going to be? Is it going to be debt? Is it going to be equity? And you'll hear, various theories on that. Accountants may look at things one way, lawyers may look at it another, but, ultimately, you're going to have to give something up to raise your capital. And it's up to you to decide, where your tolerance is. For example, if you give up equity, it means you have shareholders. It means you no longer own 100% of your company. There's another voice to contend with, maybe a minority. But now you've got a fiduciary duty, perhaps, to that minority. And ultimately, at an exit, that equity that's being purchased, it's going to grow in value and it's dilutive. And so it might be expensive. The beauty of equity, of course, is it doesn't, certainly in the short and middle run, doesn't get paid back, unlike debt. So some will think it's costless, but it's really not, because if you think about the growth rate of the company, if that exceeds the interest rate on debt equity, then by definition, the equity is more expensive. But the reality is that early stage companies might not be bankable, probably are not bankable. So it's not a regular bank loan that you're going to be able to take. And in fact, if you go to a bank will probably tell you it's more suitable that you try to raise equity capital, which in its nature is more risky. But of course, you have what's called that equity return, which typically will outpace the return on the debt. So unless you're willing, or owners are willing to sign personal guarantees, then debt might not be available to you in that early stage. Equity, on the other hand, typically comes without those guarantees. There is no personal guarantees associated with that equity. The equity is not a drag on cash flow. So that's a positive. The other thing too is once you go down that equity path, maybe it's easier for you then to think about having an equity plan to incent employees, which depending on your philosophy might be a valuable thing to have. Equity can be flexible, very flexible. Typically, the first time you raise capital, if it's equity, it's not going to be a complicated, structured security, but it can be. And later on it can be, and which means you can tune the economics of the return through preferences. You can allocate risk. You can bring the risk down for the new investors by giving them dilution protections, management rights, board seats. And these are things you don't typically see with a debt security. There are debt securities that have protections built in, particularly with banks when you get to be bankable. And they would be covenants and ratios that must be maintained, debt to equity, covered ratio. There's all kinds of mathematical ratios that the banks ask you to maintain to presumably make sure that you're in good fiscal health, or you run the risk of defaulting. Or what you will find is quite often, if you go in technical default under some kind of math ratio in your debt package, you end up just paying a fee. So it can get quite expensive. Often clients will take on debt and not fully model out the ratios that they need to maintain throughout their business cycle. That's an important piece to look at. But sort of to go back, the point here is that equity can be very flexible, and it can be modeled to give a variety of economic results, to the extent that you can have a sale of a company, and depending on what point the company sells at in price, different things happen with that security. So the security holder may get whole first from the investment, and then there's some share. Then maybe the next tranche of purchase price might go back to the common holders. Then it might revert to some kind of split. So there's all kinds of ways of slicing that equity up. Again, the flexibility that you don't see with debt. Talk a little bit about legal framework, and this gets back to this notion of exemption. We want an exemption from federal and state law. Typically, the main exemption we use it's a statutory exemption, a 4A2 under the 33 Act. And that basically says that if the security that you're selling is not in a public transaction, then it won't be subject to registration. And it leaves a little bit to be decided, or there is sort of a gray area about what does that mean to be a non-public transaction. Well, rather than guess about that, there's a set of rules, safe harbors, and if you meet the conditions of the rule of safe harbor, you are deemed to be an exempt transaction. And that's where we tend to fall. And in particular, we use Reg D, private placement exemption from 4A2, and in particular, Rule 506 is our main exemption. 506B, and more recently, that was renamed. It allowed for 506C, and we're going to talk about both of those varieties. There are other rules, but the beauty of 506 is that they preempt state law. There's a 504 that is a little bit more useful now with some rule change, and the amounts of money you can raise has been increased, but that does not preempt state law. So we're going to talk about that in over the next couple of slides. So here are the exemptions. There is a Reg A as well as a Reg D. The Reg A is like a mini public offering. And these have just been upped. And when I say they've just been upped, those rules have yet to go final. I think the expectation is they go final sometime in the beginning of February. so it's coming up. There's a Tier 1 and a Tier 2 Reg A, or now actually have a Reg A Plus. But in both cases, there will be a mini prospectus that does get reviewed and commented on by the SEC. So this is still a private transaction, but there's certainly a lot of hoops to jump through. We're not going to focus on Reg A for this presentation. So we also have a Rule 147 and 147A. It's your traditional intra-state offering. Rule 147 was a little more restrictive than 147A. It allowed for sales to from a company in a state, and that company was headquartered in that state, qualified in that state, and sold to shareholders in that state. Everything was in the state. 147A expanded that and allowed for companies that were incorporated in another state, but primarily did business in the state that they were making the offering. And while all the investors needed to be in that state, materials could flow outside of the state, just couldn't take investors. 147 was very narrow. This also, 147A had some resale changes. So you would always take a 147A over a 147. But 506, there's no real compelling reason to take a 147 over a 506, Rule 506. Even though the 147, the amount that you can raise may be sufficient, but there's no real advantage. And when you take into consideration the sort of best practice, and best practice in raising capital is to sell to accredited investors or above. And I may be skipping ahead here a little bit, but an accredited investor is somebody who makes $200,000 a year for the last 2 years and expected in the current year, or with spouse is at $300,000, and net of home has a $1 million net worth or above. That's an accredited investor. You have a tier above that, which is a qualified purchaser, a QP, and then we go beyond that. But accredited investor is sort of the gold standard. And the notion is that that is a person who can make an investment and afford the illiquidity of a private investment and does not rely on a return of that investment for their well-being. And at least that's the notion. And so those are investors also who are deemed to be sophisticated. Now, you can certainly sell to unaccredited in the right, with the right security, with the right exemption. Often there are very particular forms of documents you have to present, disclose, particularly in the financial area, if you're selling to unaccredited investors. And also, for example, in a 506B transaction, those unaccredited investors must be sophisticated, and we have to arrive at that, which means sort of educated and experienced. As mentioned, Reg D, that's Rule 506, 504. 504 has recently been and I say recently, within the last 30 days or so, being extended from 5 million to 10 million, and that's in a 12-month period. But those rules have not gone final. They're expected to go final sometime in February. No sophistication standards here for 504. And the other piece for 504, and why we prefer the 506 in most cases is that it's not a covered security, which means it doesn't preempt state law. So we have to have a state exemption, which changes state to state, versus the federal exemption. The Rule 506 safe harbor, both A and B, both preempt state law. So we meet the requirements of 506A or B. We don't have to worry about state law other than a notice filing. That's true of any security sale of a covered security, which means exempt from state law. But it does not mean that but it also requires that we make a corresponding notice filing with those states. So 506A and 506B are the most commonly used exemptions from registrations, whether it's a debt offering or and I said 506A and B. We need to wind back. It should be 506. I'm going to say it should be 506B and C. There's an error in the slide here. So let's wind that back. So Rule 506B and 506C are the most commonly used exemptions from registration. And really it's 506B. 506C is a newcomer, and it breaks the general rule of no solicitation. The basic principle behind private fundraising is that you do not make a general solicitation of a buyer or an investor. And that's been true in all areas until recently, until the 506C came along, and it allows for general solicitation. We don't see that much of 506C, but it's out there. I think practitioners are still worried that it's going to be misused because it doesn't have all the protections that a public offering has, but it's certainly available. And we'll get into the differences in a minute, but basically you have to be an accredited investor, and there's a heightened level of reporting. As a 506B offering, in a 506B offering, we ask the investors to certify that they are accredited, but that is self-certification. In the case of a 506C safe harbor, we actually have to either use a third-party verifying source, and there are companies out there that do that, or the company puts together a set or there is a list of documents that have to be provided by the investor that effectively proves that status as an accredited investor, bank certificates, etc. There's another exemption, and this one again has just changed, crowdsourcing. And the crowdsourcing rules at the federal level have just changed as well. Make them probably a lot more attractive. The problem with the crowdsourcing rules, where they were limited to $1 million total raise, and the limitations on the individual investors were relatively small. I think I've got more detail on crowdsourcing later, and we'll get to what those caps are. But just as a quick preview, as I said, the limit has gone up to 5 million, and the individual investors, if you are an accredited investor, you are uncapped. Otherwise, it's going to be between $1,000 and $2,000 per person. There are state laws regarding crowdsourcing, but the crowdsourcing federal law preempts under a different mechanism, but it preempts state law. So now we're going to focus a little bit on, or we will focus now on Regulation D and the 506 offering. In most cases, when you see a private placement memorandum, a PPM, whether it be for debt or for equity, it's going to be a 506, and more specifically now, a 506B, even though there are these 506Cs that allow for general solicitation. So what makes up a Reg D offering? Well, you're going to have a disclosure document, which is the private placement memorandum. That's going to describe not only the security that's being offered, it will more than likely have the business or sort of condensed business plan. They have financial projections, capital structure. It's going to talk about other securities in the capital structure, the rights and preferences of the security being offered, and securities that have been offered to prior investors. There'll be a discussion about management and board. And then, just as importantly, or more importantly, there will be a section about risks. And those risks should be read. They will more than likely have general risks to the business and that sector, and then specific risks to the company. And in many cases, right up front, the private placement memorandum will point the reader to those particular risk factors, why you shouldn't do the deal. The notion is that private placement memorandum should give the investor enough information to make an informed decision. And this is where the requirements of the statute, and by the way, the requirements of the statute for accredited investors is minimal. But we need to go beyond that, because we need to give enough information to make that informed decision to avoid the 10B anti-fraud provisions of the statute, of the securities laws. And, generally, go back to what I said earlier, it's the company needs to give enough information to make that informed decision. And if it does not, then it could be subject to those anti-fraud provisions that will be included, irrespective of the preemption. So that's what will drive these private placement memorandums to have substantial risk factors. I think the thought is transparency is the best plan. If you're writing a private placement memorandum and there's something you think you want to keep out because it's not conducive to the company's proposition that it is a good investment, then you should think twice about that. The very notion that you're thinking about taking it out probably means you need to put it in. You certainly can be careful in how you describe things. But I think transparency is definitely the best rule. Now, in the risk factor section, if you're a public company, you're not allowed to have language that mitigates the risk. And I think it's good practice, even though there's nobody reviewing this document, like a public offering, when you prepare your risk factors for the company, that you do not include mitigating language. You want the risk to stand by itself. To the extent there's something that mitigates, some business point that mitigates a particular risk, that can become apparent in the business description, but I would keep those separate. Best practice will say keep the risk factors insulated from mitigating language. Just as a practical matter, when preparing these Reg D offerings, what we found over years is that investors are a little impatient, like to skip through things. So we try to make these private placement memorandums as easy to follow and read and navigate as possible. So that includes having a good index, a good set of instructions that are indexed against the documents that are included in the offering, which is not just a private placement memorandum, but any kind of attachment, such as a subscription agreement, whereby you subscribe for the security that you're purchasing. Think of that as your mini purchase agreement. You might have a shareholder agreement that you're expected to sign. There'll be bylaws to review, perhaps, partnership agreements to review. Certainly, there'll be a questionnaire that's designed to bring out your sophistication, even though you might not need that as an accredited investor. And then there's a section where you sign off on how you are accredited, whether as an individual, through a group, through a trust, through an entity. There will be questions that you will answer. One thing to keep in mind, because you may wonder why there's some redundancy in these documents. We build in redundancy in case, for some reason, we don't get the exemption we're expecting to get. Because we don't meet the safe harbor requirement of a particular rule, such as a 506B, does not mean that we don't fit into the general exemption under the statute. And therefore, I might need to determine that you're sophisticated, even though you're accredited, because for some reason, I've blown the 506 offering. That exemption or safe harbor, for whatever reason, I can't meet the terms. And so I may have to go back and rely on a 482 exemption under the statute, which unfortunately means I then have to go find an exemption under state law. So I'm going to be extracting information from the potential investor in my questionnaire and other documents that will allow me to take perhaps other paths to exemption. Belt and suspenders method. This slide just talks about more what you expect to see in a private placement memorandum. You sometimes see them referred to as a confidential information memorandum, but more than likely it's going to be referred to as a PPM. Sometimes you see what is called an offering letter, and that really is just a scaled back PPM. There's not as much disclosure. Remember, if you're selling to accrediteds, there is no mandated form of disclosure. My original, when I first started doing this 20 odd years ago, I would do a PPM and it would be based on an S1 public offering document, maybe with some reduced financials. But that's how I would go about it. I would have the management section. I would talk about the security. I'd talk about the risks, and it really was patterned after an S1, scaled back just a bit. And then it would have risk factors. Often the confidential information memorandum is similar because it's a description of the business, but they're more tuned for a negotiated transaction. And remember, if we step back, when we do a PPM, a private placement memorandum, the company is setting a price, it's setting the security, it's putting it out to a group of potential investors, and we can talk about who they may be. but it's not a negotiation, or it's not supposed to be a negotiation. A different type of transaction is where the company is going to go out with a security it knows, but the terms of that security have not been decided upon. And maybe there's a discussion with an investment or a private equity firm, and that private equity firm may bring in other partners, but they're the lead, and there's a negotiated result that leads into the formation of a particular security, often a Series A preferred, convertible preferred, and it's a negotiated transaction. There's a back and forth, and then rather than risk factors, the company actually makes reps and warranties about the business. That's quite a bit of a different form, and not something we're going to discuss here. As I said, that's more of a negotiated transaction rather than an offering by the company. Sort of the differences or similarities between the 506B and C. You know, in most ways, the 506B and 506C are the same, similar. No limits to the dollars that you can raise. You have a bad act of disqualification for both. If you have accredited investors, it's unlimited participation. But this is where it gets different. So 506B allows for 35 non-accredited investors. They may participate if they're sophisticated. Extra disclosure may be necessary, more than likely will be necessary. But as I said, the general thought is that accredited investors are to be preferred. The 506B does not allow general solicitation, and that's sort of the general premise here. It was about all Reg D offerings until just a few years ago when 506C appeared, which allows for general solicitation. But if you go down the path of a 506C, you cannot go backwards and then choose to close out as a 506B. When you fill your Reg D form out, we can talk about what forms have to be filled out with whom, you choose between B and C. You can always, I hate to use the term upgrade, but change your 506B to a C. You cannot go the other way once you've actually solicited. So just once you do a 506C, I think it's wise to stick with that 506C. So, you know, the question comes, how do I actually mechanically do this? How do I raise money? I've read things on the internet. I've heard horror stories, not wanting to do it wrong. How do I get out there if I cannot market the transaction, if I cannot market the shares? Well, the common and traditional rule is that you must, as the issuing company and the officers, managers, and affiliates of that issuing company, only sell to those that you have a substantial pre-existing relationship. And the question is, what does that actually mean? Well, it turns out that if you have a Rolodex and you've talked to, and of course that's the old-fashioned way, having a Rolodex, if you've got 100 names on there of people that you've contacted in the past for business reasons, that may well be enough to substantiate a contact and avoid making a solicitation to somebody you don't have that pre-existing substantial relationship, meaning the bar's not that high. And then you say, well, what about, how do I go wider than that? Can I use a consultant? And there are certainly in most communities, local businessmen, ex-businessmen, consultants, people who believe themselves to be connected. Maybe they are, maybe they're not. And they will offer to help you raise capital. And the question is that legal? Well, Alabama has traditionally frowned on using a finder I'm going to define that in a minute and talk about the new rules, but has allowed a pure consultant. And you say, well, what's the difference? Well, a pure consultant doesn't get paid in a contingent fashion. That consultant comes on, it can advise, it can help, it can set meetings up, but it's on a fixed fee. I've seen creative ways of paying consultants that really try to mirror the contingency. But at the end of the day, if there is truly a contingency in the payment, and without the investors coming in and investing, the consultant isn't getting paid, or when it does get paid, it's a percentage of what gets raised, that's a problem. You can use a broker-dealer. This is a registered broker-dealer. Part of doing that is making sure that you announce that, disclose that to the potential investors, typically in the PPM. I sort of jumped ahead how you use a consultant. If you do have a consultant, then it's a fixed fee, no contingency. But interestingly, in this group of rules that just came through at the end of last year, there are new rules for finders. Finders are broken up into two tiers. One is sort of the finder who will do one transaction a year for one client, de minimis. And then there's the finder it's more of a business for that finder. Now, as a finder, you don't get in the middle of the transaction. Your job is to find potential investors and put them in touch with the buyer and let them sort their deal out. But we are going to see these new rules for the finders coming in. There is a question about conflicts between state law and federal law. Alabama has very specific rules on not using a finder. And it's one of those areas where if they get a complaint from a potential investor who calls up the Securities Commission in Alabama, says, you know what, I just got this call from this guy and he's trying to sell me stock here and I don't think he's a broker dealer. Can you look into this because he was harassing me? And they do. And they not only look into the companies, they take these things finders very seriously. It's kind of a hot topic for our Alabama Securities Commission. They have investigators that investigate. They go, they look at bank accounts. They try to match up deposits, presumably from investors at the company level, with payments made to finders under some kind of contract. So they're pretty hot and heavy on that. I don't know how the new finder rules are going to interact. That's something I'm watching, waiting for those rules to go final, and then see what happens. Filing requirements. So what do you do? So again, the Reg D is a safe harbor. If you meet the terms of the safe harbor, then you get to preempt or avoid state law filing requirements. You do need to make a notice filing, which is pretty minimal. But you do have to make filings at the federal government. Now, interestingly enough, if you fail to fill in your Form D and supply it to the government in a timely manner, which is typically 15 days after first sale, that does not stop you claiming the benefits of a Reg D. Now, states have taken different positions on this. Some states have said, well, wait a second, if you haven't filed the Reg D, then you cannot preempt state law. I think the answer is if you've met the requirements of Reg D, done the things necessary other than the filing, you have preempted state law. But that battle gets fought, I won't say all the time, but it's been fought quite a few times. In most cases, the covered security theory wins over, not always. So the trick is let's stay on the positive, on the plus side of that. Let's make our filing within 15 days. It is a relatively easy online form. It's going to have some data items, including the price, how much have been sold, we're continuing to sell, and potentially where the residents live. Particularly if we're going to do 504. Actually, it's going to have all the states now, because in the new Reg D forms online, we will indicate to which states we've made sales. Then there's an online portal to do your state filings. Not every state subscribes, but often you can do multiple states in one filing. One tricky state to remember is New York State, and that is, it's sort of bizarre. In New York, to follow the filing deadline to the letter of the law, you would actually file before you made your first sale in New York. So it gets crazy, because if you do an offering in Alabama and you haven't contemplated filing in New York, but you end up, for some reason, somebody comes in and says, I want to buy some shares. They live in New York. You've already made a sale, and let's say in Alabama, you sell to them, you are immediately in breach, violation, theoretically, because you have not filed your registration. There's a lot of argument among the bar in New York about this topic. There is I think, a disagreement even at the Secretary of State level. Typically, we file as soon as we know we have a New York participant, and I've done that many, many times. And I think almost everyone has violated, theoretically, the timing, because they didn't know that we were going to sell in New York. I've made my filings, paid my fee, never had an issue there, but that's what the state law says. So, and then, and the last point, 506C, allowing for general solicitation. I think that could be dangerous, but it does appear to give a fair amount of free latitude to advertise for the sale of securities. So mechanically, you want to do a Reg D. What you need to do, apart from all the prep stuff we talked about, we need to get EDGAR filing codes for the company. That all can be done online. The Reg D is an online form. There's just some very basic company information, such as size, revenue, and there's ways to redact some of this. Names of offices, but not a lot more than that, as you'll see. And I think I mentioned before, failure to timely file is not a condition to the availability of the exemption. So even if you don't file, you still theoretically have the exemption under Reg D. So now we're going to change gears and talk about convertible debt. It may well be that a company's not ready to take on equity, or it may have a valuation issue, doesn't want to put a price out. And so, and again, this is convertible debt from private individuals, private equity, not really bank debt. That would not be typical. The notion is that this debt is going to be shorter term, and it will convert at some discount into the next round of equity. Sometimes it's associated with warrants. We're not going to get sidetracked with the warrant discussion here. That's used to sweeten the pot. Notes typically unsecured, certainly going to have an interest rate. Often we see that the interest rate is more favorable than what we think of as mezz debt, which is also unsecured. That's not necessarily a rule, that's negotiated. The interest is often paid at the end, and it may be even convert over into more equity. Again, that's sort of to be negotiated. The conversion, and this is where it gets a little tricky. From a company point of view, company would like automatic conversion, meaning that if there is another round, at least some defined set of circumstances, the round is certain size, maybe it's been subscribed to at a certain level, then the debt holders will and must convert into equity. Sometimes that's not the case, and it's a may convert, which means it also may be bought at, may have to be retired. So again, that's for negotiation and depends on the situation of the company. The other couple things that happen with convertible note, there may be a cap that's put on a valuation for conversion. And remember, whether it's a cap or a discount, these are things that are disclosable to the investors in the next round, because somebody's got to bear that cost, that the cost of the cap, and then the cost of the discount even, because these investors are getting in to a round at a price cheaper than the current investors into that round. So these things have to be considered as potential chills on future fundraising. Sometimes it's looked at that way, sometimes it's not. But they should all be understood by management, all these provisions, because it certainly does have an impact down the road on value and perception when you're raising cash. We mentioned earlier a SAFE, simple agreement for future equity. It was created by the Y Combinator, and it was an alternative to a convertible note. Couple things to kind of keep in mind with a SAFE. The argument is that it's not true debt and it doesn't sit on the balance sheet as debt. But the issue is that if something goes wrong with the company and there is a default, or the company is going bankrupt, it's not clear that the holder of the SAFE, where they sit with respect to assets of the company and getting paid back. Certainly if they were a convertible note, even if it wasn't secured, which mainly they're not, it's still sitting ahead of the equity players. Not so with a SAFE. So it's very unclear, how they get paid back, if they get paid back. And I think that is actually quite a big risk of holding a SAFE. The fans of the SAFE will say it's relatively cheap, it's cheaper than a convertible note, and it doesn't have to have interest rate on it. So again, the interest rate is always a negotiated piece. So I'm not sure how convincing that is. And as far as price, and cost, I don't see it being any cheaper than a convertible note without the protections that a note gives to the investor. And certainly from the company's point of view, maybe it's ambivalent, but the investor says, hey, I would rather be in line as a debtor if this thing fails. So, but beyond that, same kind of variables, that there's a conversion factor. And again, it may say no interest, but the flip is you can just build that into the conversion rate. So when that SAFE converts into stock in the future at some discount, then that can account for any interest. There may also be caps. Same with the valuation cap on a convertible note. So in many ways, it looks the same. It's just not treated the same on the balance sheet. And certainly in liquidation, I would say that it's going to be inferior to a promissory note. I've done them, but I'm not sure that they're necessary. There are other entities out there that have come up with enhanced safes. But again, I'm not sure of the advantage over a traditional convertible debt instrument. Excuse me. I want to move on a little bit to crowdsourcing. So let's turn now to crowdsourcing, which is allowed under Section 4A6 of the securities law. This is known as the crowdsourcing rule. It's recently been changed. It first came in under the Jobs Act, and it was restrictive. Approximately $1 million max, and the investments were, if you made under $107,000, you were going to be limited to $2,200. And if you were over, then it was 10% of your salary, but effectively about $10,000. 10% of your salary or 10% of 107. That's changed now. So it's 5 million. At least it will change as of this February. $5 million max. If you're an accredited investor, then you can put in as much as you want. And then if you make over 107,000, it's the greater of 10% of your annual income or 10% of your net worth, not to exceed $107,000. So there's been some significant changes coming up for crowdsourcing, but you still get back to the same base issue, and that is you may end up with hundreds and hundreds of shareholders, and if you think it's hard to manage 5 or 10, you're in a different world with hundreds of shareholders. Now the good news is you will not be treated as a public company because of the number of investors that come through crowdsourcing. But you've really got to think very carefully if you want to go that crowdsourcing route. Good news is, though, there is more available cash. It looks like these rules will preempt state law. Every state has its own set of crowdsourcing rules. But I think that the new expansions will end up preempting state law. A couple things about crowdsourcing generally. It's going to be all online. There will be a Form C. Think of the Form C as sort of your PPM, your disclosure document. That gets looked at and filed ahead of doing your crowdsourcing. I've got a lot of little items here, things that will be included in crowdsourcing offerings. You can sort of read that at your leisure. And then some requirements on the Form C itself. Now, one thing to note, if you are in the process of doing this, or you have done it, and you have financial obligations, financial statement obligations under crowdsourcing, there was some temporary COVID rules put in place, and they may be extended. And you can read a little bit about it here. Well, actually, that's more of the financial requirements. And I've got a slide here about the current COVID relief, which right now is extended through the end of February 21. Let's wrap up and summarize the discussion. Most companies get to a point where their initial capital is wearing thin, and they've got to raise external capital. The choices are go to the public markets, stay with the private. For most companies, early stage, public market is really not a viable option. And in fact, today's markets is more or as much money available on the private side than there is on the public side, potentially. Certainly, when you look at the transactions that get done, the volume of companies going public, you'll see that the private side is still dominating. Then you got a decision. Do you want to do equity? Do you want to do a debt? Do you want to do a combination? Combination being a convertible promissory note would be a good example. It's debt, but ultimately it converts into equity. Before we get there, we have to make sure the company's in good shape. We take all the things that are under the company's control, whether it will be filings, contracts, doesn't matter. Things that will be looked at potentially by outside investors and doing their diligence. Get those shipshape. Make sure you got answers for everything. Make sure everything's buttoned down. Then you want to make sure that your managers, directors, they're all on board. They understand their roles. We talk about valuation, if that's appropriate. If we're going to set a price for the company's shares, it's got to be a price that's fair to the company, fair to the current shareholders. We're going to look at who those potential investors are. Is it early stage? It's going to be friends and family. Is it going to be professional, sophisticated investors? Is it going to be private equity, so professional groups of investors rather than individuals? There is another group of investors out there, that these angel networks. Didn't really touch on them. These days, they act more like professional investors. The downside to an investor group or even an investor is that they may not have the legs to sustain multiple investments like potentially a private equity investor might have. So they're ready to make their first investment, but when the second investment comes along, and that might be a planned growth with an investment downstream, they're just not ready or able to do it. So just be careful with those angels and individuals. They may be a little fickle in follow-up investments, even when the company is meeting its requirements. Then we think about, as part of getting the company in shape, make sure we got a good business plan, good model. That will fall into ultimately disclosure documents. When we talk about the business, we think then about the overall landscape, legal structure, the fact that we need an exemption if we're going this private route from federal and state. And ideally, we preempt state law by going down a federal safe harbor route, typically a 506 offering. And then we execute on the documents. So we get the documents in place. And now we've got to push those documents out to investors. So we've got to meet the right investors. And assuming we're not doing a 506C or potentially a Reg A, and we're sticking with private solicitation. It's not out in the public. How do we do that? Make sure that we don't have consultants running around trying to place our stock to people we don't know and working on a commission. Absolutely not the case. Now, one other thing to add, and this has come down with some of the new regs coming out, will be the ability of the company to demonstrate, demo days. It's more than that. It's not just demonstrating its technology. It's really pitching. And this has been a gray area in past years at these pitch competitions. What is that a public solicitation or not? How are the people getting invited to these pitch parties? Well, with the demo day exception, we get a little bit more coverage. And as long as the demo day is put on by university, institution, nonprofit, incubator, an angel network, these type of organizations, we sort of free ourselves up of the worry of a public solicitation. And so that does give the small company a little more coverage when it's going out and pitching itself. So there's a lot of those opportunities. But what you got to be careful about are the pitch parties where people pay to go to attend the pitch meeting itself. That's a little tricky. Now, if you're going to go to one of those, what you want to know is that all those attendees really are already have pre-established relationship with the organizer of that pitch party. And if that's the case, we feel a little bit better about it. But you should be aware of that. And as I said, with the new rules coming into play in the next month or so, there's been a little bit more clarity given for the pitch parties. So once we figure out who we're selling to, how we're going to sell it, the sort of notion there is full disclosure. You don't want to be hiding things. If any risk of the business that we know about, let's put it out there. Then make sure, of course, that we don't have any bad actors in senior positions or major shareholders in the company, because that's going to limit our availability of exemptions to the securities laws. So we will sell, and then we will file our Reg D. We'll need to go ahead and get the filing codes, all online. It's pretty easy to do. File the Reg D. The state filings are mainly online. I think New York may not be. There's a couple of states that are not. The state filings and the Reg D, at least 506, are going to be notice filings, not subject to review. In fact, the Reg D offering itself is not subject to review. We're going to provide basic information about the company and the offering through the EDGAR system. And it's on file. It can be reviewed by anybody, but it's not a lot of data in there. And that's what you need to do. Now, if there's a major change in the offering, you can file an amendment to your Reg D, which you may need to do. And then you're going to take the funds and you're going to have shareholders. And that's when the fun begins, because you've got to be very careful. You've got shareholders now. Keep the formalities up. Realize you have shareholder meetings. Board has fiduciary duties. When you take into consideration actions of the company, it's not what's going to just benefit the major shareholder. It's the company at large. And it's certainly good to have that discussion with your counsel about these fiduciary duties that are owed, particularly at the board level. And I think that's it. Thanks for listening.